Adjustment of status best practices is what we're going to be talking about today, guys. My name is Sam Shihab with the law firm of Shihab, Burke, and with me,
Brian Burke from Shihab, Burke.
What better time to talk about adjustment of status and what to do and what not to do than now?
What do you mean, what better time? The government has come to us with a metaphorical gun in their head saying, you're going to talk about adjustment of status because we're moving the Visa Bulletin, you know?
Visa Bulletin moved in the family-based immigration and employment-based immigration significantly, or more significant than other times. Last 18 months is also. Like
Yeah, it's a snooze fest, yeah.
And a snooze fest, thank you.
I always have something for you.
It was a snooze fest,
Yeah.
Brian says. And we had a movement, and this movement is significant. A lot of people are contacting us about adjustment of status applications, movement in the family. Some of it is significant, some of it is measurable, good movement, and employment without a doubt has moved forward also in a good way. So let's talk about what's there to learn about adjustment of status and best practices.
Yep.
First and foremost, Brian, and I know we have a list of things to talk about. First and foremost is accuracy.
Sure.
Accuracy in your application, because we are right now in an administration that expect that from you. You are expected to be held to an absolute accuracy in every question. There's a lot of questions.
Yeah.
The sloppiness is going to get you in trouble.
Yeah.
So you really got to understand every question and have a law firm. Don't do this at home. It really isn't worth it. Have a law firm do it for you, and ask questions. And the law firm that does not have the time or bandwidth to answer your questions and ask a lot of questions, that's not what you want to be. You want to be a firm that asks questions. So this is one thing that I want to.
Yeah, I mean, some of the sort of scariest news stories from, coming out of the initial days of the new administration was basically, we're going to go back and look at your filings to make sure that you're accurate. If we find out you're being untruthful, we can use that against you, essentially.
So in immigration law, there's something called discretion. Discretion is a big piece of the immigration process. Discretion meaning that a leeway or wiggle room in the middle where the government says, well, you may have overlooked this, but we're going to let it go.
It doesn't matter, to us really.
A mistake, we're going to let it go. The discretion piece right now has shrunk.
Tightened up, yeah.
Into a millimeter width.
Yeah.
Or two.
Yeah.
Meaning that there's really no discretion. If there's errors, they're rejecting or denying. They're sending cases. There was a case that I'm familiar with. That they send it back because, not because the wrong filing fee or there's no filing fee. You wrote us a check and we don't need a check.
Yeah.
They could have easily got rid of it.
Yes. Yeah.
They were wrong to begin with,
Yeah.
but they rejected the case because, this application is for free, but you included a check.
Yeah. Exactly. Yeah.
Just don't cash the check.
Yeah. Take the case, send it back. Yeah.
Yeah, send the case back.
Yeah. Send the check back. Yeah. Yeah.
Send check. No, they sent the whole case
Yeah.
back.
Yeah.
Of course, we sent explain to them that they looked at it wrong and the filing fee is appropriate, and they moved forward. But
Yeah.
you have to be careful.
Yeah.
So that's one thing. The second thing, Brian, adjustment of status. Let's talk about family for a couple minutes.
Well, yeah, I think both talking about filing and timeline considerations is sort of a good topic for both of these things, because my favorite thing about the family-based world right now is sort of the F2A category for everybody, because the dates for filing for the F2A category.
What is F2A?
F2A is permanent resident, your spouses and your children, right?
So application for spouse and or children of U.S. permanent residents.
Yes, sir. And so that's a category that's sort of backlogged and stagnated for a while, and it had a big move. And the sort of crazy thing is how far the dates for filing moved on the F2A category for everybody, all countries, China, India, Mexico, Philippines. It says that the dates for filing for the F2A category are now 22nd September 2025 for the month of October. That's 5 days in the future from now. Meaning, if you're in a situation where you have an F2A, somebody who needs a green card through you, a spouse or a child, if you can get the I-130 case in before September 22nd, 5 days from now, receive it before September 22nd, you can get file an I-45 for them in October. Crazy,
And if you don't do that by September 22nd in the next 4 days,
Yeah.
you cannot. If you file the I-130 late, then you cannot file the adjustment.
Yeah. Yeah.
So U.S. permanent resident married to a foreign national who is currently here in the United States, let's say on an F1 visa,
Yep.
student visa, or on H4,
Yep.
whatever. Well, they're going to be on H4.
Yeah. But unlawful non-immigrant status waiting to apply for a green card, yeah.
On a student visa or any visa.
Yeah.
And you are a permanent resident, apply for the I-130 in the next 4 days, because a week after that you can apply for their adjustment of status. If you miss that window, which is a 4-day window from today, you're going to have to wait until the visa bulletin moves to further down the road.
Sam, sir, I had an epiphany. Turn on your microphone.
All right.
Thank you for Raj's channel in the chat, and I figured
What
that
is saying?
Sam's voice is not audible.
Is not okay.
I noticed what was going on. Yeah,
All
there
right.
you go.
All right, sounds good. So let's keep going.
Okay. Then there's talking about, when to file your, the filing considerations of your employment-based case.
Yes.
So I guess first thing is, are you employed with the employer that has your I-140? Is a good question. Now, there's no requirement that you be employed by the employer that holds your I-140. It's issuing the supplement J that allows you to file the I-485. And they can approve a green card for that case, and I've been through tons of cases where they've done that. But boy, howdy, do they find it interesting if you are not employed by if you're in the United States and employed by somebody else who is not your I-140 sponsor, and they're sponsoring, for a green card, essentially.
Well, they're interviewing anybody anyway, everybody anyways.
Yeah.
The question becomes is when you're called for an interview, at that time you must move to this I-140 employer.
Yeah.
You don't have to quit now and move to the I-140 employer, but they are going to be very much interested to hear about your employment with the I-140 employer if they interview.
As a bunch of attorneys, we can sit here and say, well, in theory, you're actually your only requirement is to join the employer upon approval of your green card, and that's the sort of great attorney argument that a USCIS officer will laugh at, essentially. They deal with their level of conduct.
So you walk in and say, once you give me the green card, I'm gonna start working there. They're gonna laugh.
Yeah, it sounds like a great idea until you think about it at all. Say, well, cool. I'm gonna use my discretion. I'm gonna put this thing in the oven for a little bit while longer, and I think about this, talk to a supervisor, do some research, etc.
And send you an RFE telling you why I'm not going to approve it.
Yeah, I mean, as an attorney, I think a lot about, I want to, exercise my client's rights to the fullest, but there's a certain thing called taking the path of least resistance, and making things easier for yourself by basically giving the government what they want.
Second one, the status violation problem. Brian, so if you are born in India or China, and now you're current on an employment-based application, you've been here for a long, long time.
Yeah.
And if you've been here for a long, long time, the chances of hiccups in your status potentially there.
Yeah.
The question becomes how to disclose it, how to work with your attorney to resolve it, how to anticipate how USCIS will address it is critical to the I-485 success.
Yeah.
Hiding it, covering it, and assuming nobody will catch it is the biggest mistake you can make.
We've sent plenty of people to interviews with basically an INA 245K explanation. For those who aren't aware, INA 245K is a section of the law that essentially excuses up to 180 days of unauthorized employment, violation of status, or overstaying of 994 for an employment-based green card applicant. And we've sent people to interviews. Sometimes they want an attorney with them, sometimes they don't, with a nice INA 245K letter. And that 245K letter gets them through. They're honest in their forms. They hand over a 245K letter to explain it, and that's that. But you have to be careful with those things. Sometimes people will tell me, Brian, I'm in the clear. I used INA 245K. That whole nasty status violation was during a prior visit to the United States. And my question for them is, well, were you honest about that status violation when you last applied for a visa? And the answer is, ooh,
So I think discuss it with your attorney.
Yeah,
I think what Brian's trying to say.
Yeah, it's not an easy situation to. You have to be honest in the forms, but you can plan things so you can be honest and still get your green card rather than torpedoing your case.
Yes. Disclose it to your attorney so your attorney can help you work with it. So status violation is a big one. I've had a guy recently who has been here in the US for a very, very long time. In the first 3 years of their H-1B status, they were not paid. and they stayed here in the United States and then left, and then finally found an employer that paid them. And then now, fast forward 15 years, he's doing an adjustment application and now going for an interview. Very nervous. And we put together a presentation. We walked in, he was able to disclose everything in writing, explain it. That transparency helped the officer to feel good about him. And the officer at the end said, "You've been here for 15 years. I'm going to get you this green card approved." And although he is entitled to it because he left and came back several times, he really in good shape, but the way that he was very transparent and explaining why he should be approved and explaining the law made the officer comfortable. And that's what you want to be in that position.
Yeah,
Not trying to hide things and then assume and trying to duck things, and that's not a good situation.
I mean, whenever I'm doing with interview prep, my position is I always want you to be the most honest person they've encountered, because I don't want them to be paranoid about you. Is the bottom line.
Is downgrade needed, Brian?
Yeah, I mean, so we are still dealing with the fun phenomenon that is EB3. The more easily accessible category is more accessible, more available, more open in terms of Visa Bulletin than EB2. And I'm getting downgrade requests right now. There's common questions about, should I file that downgrade with premium processing? Can I file the downgrade now in September and then wait until I get a receipt notice and file my adjustment in October? These are good questions. Bottom line is, there's going to be a rush of new I-140s. I expect the processing time to go down or go up in terms of duration a little bit.
Good questions, but complex questions, because when you're trying to rush an I-140, you have to look at the children and make sure that you are not running afoul with the opportunity of your children to become a U.S. citizen in terms of
Child Status Protection Act.
Yes, so that's an important thing. So there's a lot of considerations when we look at those things in trying to help you out with the decision. But it's critical that you understand that these things are complex and intertwined.
Yeah, considering the change in policy, it's possible you could be locked in based upon one I-140 under the Child Status Protection Act if you say filed your an I-45 in the EB2 category when your priority date became current, but they changed the way they're counting, when your dates, when you get locked in, they're going by final action dates now rather than dates for filing.
Yeah. There are interview pointers. We'll skip those, like know your labor certification. These kind of interview pointers as we're running out of time. Just be aware of the enhanced vetting culture that we have. So now USCIS is required to do more in digging deep in reviewing a case, and that's something that is going to get you into USCIS asking more questions than normally they do, and be aware that that's going to happen and be prepared for it. And therefore, you want to be as honest. So enhanced vetting, meaning that US is going to ask more questions, and honestly, they are going to be very critical, and they're going to look at it in a very skeptic mindset. That's really what we want to talk about with the adjustment status. Of course, that's scratching the surface. There's more to it. And we're going to turn our attention to answering your questions in this 30 minutes. A lot of questions came from immigrationquestions.us, and it is a website that we own where you can drop your questions in. You can do it during the week if you remember a question during the week. And a lot of time people now are less comfortable asking questions on social media because maybe that question can be traced to them and they're not comfortable asking sensitive questions. So you can drop it on immigrationquestions.us. You don't have to put your name, you have to put the correct email address. And we will bring as many of those as possible here to answer those questions, and this way your privacy is protected.
Cool.
With that, Brian, what do we have here?
We got a long one here from somebody who I'm going to abide by practice and not name, because it sounds like they might be their real name, but here we are. AOS applications pending since October 2020, with this guy's being the primary application, and we filed EAD and AP for 5 years. My priority date is February 12, 2014, India, in the EB3 category. I have 2 DUIs, one back in 2014 and another in November 2024. The DUI case in 2014 is closed. We provided related documents while filing my AOS back in October. However, my second DUI case from November 2024 is still pending in the court. What is the impact of these DUIs in the current administration? Do I anticipate an interview for sure when my priority date becomes current?
So I'm going to simplify this. Criminal background. This gentleman has an adjustment status pending and has 2 DUIs. Was the first one convicted, or was it?
It just says it was closed, and we provided documents. I presume there's some sort of actual, conviction of something related to the UN. Yeah.
So there's 2 criminal convictions, or one pending, one is concluded. And what's the impact of criminal convictions on my adjustment of status? And the answer to that question is very relevant piece of information, and it is going to be on the form. And is going to be, you're going to be, especially DUIs, you're required to disclose these fully.
Yeah.
Now, there's an exception called the petty offense exception, and the petty offense exception, if you've had under certain circumstances more than one, I think up to 2 convictions, you may be able to sidestep them under certain circumstances.
Well, you're presuming they're considered morally turpitudous, and whether these things are considered. So, crimes involving moral turpitude can render you inadmissible. In some states, some DUIs might be involving moral turpitude, and maybe you can get out of one of them that way. The thing that worries me about this, well, first of all, for an ongoing case, there's going to be an RFE where I would high likelihood of. They do a background check. They say, you have a pending DUI case. Tell us what the status of that is. And they may put your case in abeyance until they figure out what the disposition of that case is.
100% they will.
And my other concern is basically the discretionary component. It's, adjustment, again, we talked about this on Monday. It's adjustment of status is a kindness. Generally, under the oldest of laws, it's the expectation is you get your visa, your green card through the consulate. And I wonder how they're going to treat these things in this environment of, 2 DUIs? Well, we can just, whether their discretion, we'll have to look at the discretion rules on I-45, essentially where it lies.
So yes, I mean, right now, as we stand today, September 17, 2025,
not hearing problems with that,
there's no published policy about not approving adjustment of status if it does not meet any of the grounds of inadmissibility.
Yeah.
Okay. So right now, but I won't be surprised later on for them to tighten that up. But what you need, and I'm assuming on your second conviction that's pending, what you really need is to have an immigration attorney involved with the criminal lawyer. Now, there's a lot of criminal attorneys who are not interested in getting an immigration attorney involved. If you have one of those, dump that lawyer, get rid of him, and get an a criminal lawyer who's either have knowledge in immigration law or willing to work with an immigration attorney. Because the consequence of an attorney who is so busy or so overly confident, who has no immigration knowledge, can be devastating for you.
Yeah, something I tell people all the time is part of being good at my job as an attorney is admitting what I don't know and bringing in somebody else that's their bread and butter. Why would I'm going to tell you I am gangbusters good at immigration, but that's that. Bring in an expert when you need an expert.
Let's take the next one.
Yeah. Let's see here. So, I brought it up here so we can put it on the screen. Pretty sure it's the one. Yep. Wait, no, it isn't. Got my EB2 priority date. No, they don't have it up there. Yep. My EB2 priority date is January 3rd, 2013. Got my ED AP in October in 2022 through my previous employer. Should I file new I-45 from my current employer or an amendment? What steps should I take with my current employment?
So that leaves some gaps in the question that are not clear.
Yeah.
One of them is he doing an AC-21 and transferring it?
Portability. I-45J portability.
Is he transferring, or does he have a new permanent I-140 with a new employer?
Yeah.
So if you are working for a new employer, through a supplement J, you can move that case with this with you, and that's that. That's all what you need to do.
Yeah.
If you have a new I-140 and a new perm, and the job is not same or similar to the previous job, then you need to file. So more information is needed to give a good answer to this guy.
I think the general answer is, if you have a pending I-485 through your EB2 case, if that job offer is still valid, you can don't leave that alone, but you should find some way to take advantage of the EB3 availability right now. Try to get in that line as well. Take a chance at it, Yep. Let's see here. So long one here. Just saw that USCIS released the Visa Bulletin. Final action date for EB2 moved to April 1st, 2013, and my priority date is February 26th, 2013, which would make me current in the next month. Maybe, who knows? What are the next steps to get the green card petition to move? And is there any documentation we need to submit? So maybe some first questions there. So I would say, being a squeaky wheel, sending a letter to USCIS as a polite reminder of, hey, my priority date's current. Please adjudicate my case is something that we've done a fair amount around here. Mm-hmm. Yeah, that's a fair answer.
Yeah. Would you do a phone call? Do a service request?
Service requests are so rough right now. Somebody called me this morning and said, Brian, my EAD is not in. And I talked to him on the phone. I said, well, looks like you're beyond normal processing time. It says here you can put an inquiry. Well, after I hang up the phone with him, I go to the put in an inquiry page, and they say, you're within normal processing times. So I have such little faith in USCIS service requests.
Medical August 2023, do I need a new one?
Yes.
But the answer is you might want to wait for an RFE and not get one right now.
Yeah, because they are valid for 2 years from the date they're signed.
What's the timeline looking like to get approved green card in hand? Obviously, that is going to be something that you should look online because it's going to be on a case-by-case basis. We have to know the dates filed, the processing time.
Yeah.
But we're looking at what? We're seeing 18 months from filing? Yeah,
like here in Columbus, they say most, it's a change because ultimately previously I was going by service center dates. Now you're going to go by local field office dates because presume your case is going to your local field office. Basically, so
interview.
Yeah, I mean, I'm not hearing anything. This person's been interviewed before. I would expect an interview.
Yeah. So that's what you're looking at potentially.
There's a lot of flux in the policy, and I basically think odds are you're going to get an RFE and an interview notice if I'm a betting person,
medical.
right? Yeah, and you're going to need a new medical as part of that RFE for sure.
All right. So jump into the next one.
Yeah. Please keep me anonymous. Okay, anonymous. Sam, do you want to do it?
Okay, I have recently approved I-140 and current priority date. Okay, congratulations. The attorney believes there was a mistake on my job announcement that prompted this perm process. Keep this private, blah, blah, blah. Okay. So because of this, they restarted the concurrent perm process to correct it. Now the I-140 is approved. Should I go ahead and file I-45? Will this still be a potential issue? So I-140 is approved. Then they discovered an error in the perm. Then they did a second perm.
Working
and
on
they
one
filed
right now.
Well, does it look like and it's approved or not approved?
Looks like because this
now that I-140 is approved, should I get ahead? So if the perm is still pending, and the employer is telling you the perm has a problem, it's not a good perm, I wouldn't file. I would not go forward.
With the I-140,
Unfortunately.
Yeah.
The problem you have is also that priority date is not a good priority date either.
Yeah.
And the government does not know that. And how you're going to fix that, because they may still trying to move you in that priority date and expose you. So it may have to be after the perm is approved and hopefully you have enough H-1B time. You may have to come clean with the government and say, please disregard this priority date, the perm. We found an error after the fact. We didn't use it. Please don't use that.
Different fact. You're presuming it's the earliest priority date. I'm presuming there's somebody from a deeply backlogged country like India or China, meaning India more likely, that if that's not the earliest priority date, it's not.
So if there's a prior I-140, you can use it.
The only impact is you basically throw away this I-140 and you file based upon the new one when it's approved, essentially. Yeah.
So if there's an earlier I-140 and an earlier priority, then you're in good shape. If this is the earliest, then there's a problem.
Yeah, you have the bummer of losing your early priority date, essentially.
And this is an example of why immigrationquestions.us can be helpful, where we can answer questions that are very, very important, that maybe your information is not disclosed and it's not on your social media handle, so you keep your stuff private.
Yeah.
All right.
Here's one I'm going to be able to put up here, and I should have taken down
I want to give us some attention to also people posting here.
Yeah. Okay. Yeah. The live questions.
Yeah.
So let's see here. Thanks, Raj, for pointing out the Stan Voice issue. An employer does not allow me to apply until I receive an RF. maybe Harsha, some of this got cut off, but my employer does not allow me to apply until I receive an RFE. I wonder if he's still referring to like submitting a supplement J. That's that sort of thing.
Not enough. Not enough for me to. Harsha, sorry, not enough information.
Yeah.
If you can drop an explanation, we'll do our best to answer it.
Here's one from Srini.
And if we don't catch it now, drop it in immigrationquestions.us and we'll catch it next week.
Yeah.
All right, Srini. Is CSPA provision applicable to a child whose biological age was under 21? Officer refused to apply CSPA provision because child's actual age was under 21. Child was in a near age out situation. So the CSPA provision, 100% applicable, specifically applicable for people who are under 21. So I don't see how can these...
But I need more context because, like, you know, if they're about to approve an I-485 for a child who's still biologically, in fact, under 21, there's no need for the CSPA.
Well, if that's the question,
Yeah.
So I mean, it doesn't matter if did your child get the green card?
Yeah.
If the child the green card, I could care less whether they apply the CSPA or not. But the CSPA applies for children who turn over 21, but you can give them time credit for government delays, such that they could be treated potentially legally, not actually under 21. So maybe we answered the question, maybe we didn't.
Yeah,
if we didn't, please clarify.
Yeah, I'm
Let's
seeing
go to the next one.
officer refused. It sounds like an interview scenario. No officers are going to want to talk about the CSPA during a green card interview. Is my take on that. Okay, I think I put this question in here. Here it is. Can you travel with a valid H-1B visa stamp after filing I-485, but before the approval of the advanced parole? If not, how long is this period typically? So
the answer to that question is yes, you can travel. However, right? However, your advanced parole will not be approved because you've left the country before it was approved, and you have to come back and apply again.
Yeah.
And so if you're on a valid H-1B and you have a stamp and you're not subject to having to go back to the consulate and be at their mercy, and Brian just looked up the processing time for advanced parole, which is 11 months on average. And if you have to leave the country, then be prepared to file a new advanced parole when you return.
Yeah, I think my wife explained it. The rule for everybody is that if once you file adjustment of status, you're not supposed to travel. But there's a special rule for H-1Bs and Ls that say, well, you guys can actually travel because you have immigrant intent allowing visas. You can apply for advanced parole, but if you use that visa during that, adios to your advanced parole, unless you already have an approved advanced parole, it used to be their policy.
Yes, it still is, I think.
Yeah.
Extension.
Touch wood, anyway. Yeah.
Advanced parole, refiling, which is stupid.
Yeah.
But that's the rule.
Yeah.
All right.
Another one here from. Let's see here.
Again, we're pulling from immigrationquestions.us where you can
take our. Where's my window here? I'm going to take that question down so we make sure we don't have the wrong one up there. And there we go. If money is not an issue, does it ever make sense to use transfer underlying basis against filing a separate I-485, one with each approved EB2 or EB3 I-140 petition?
Well, you're preaching to the choir. Brian and I, for the longest time, have recommended a dual filing rather than transfer underlying basis. Transfer underlying basis is a nightmare. And I know there's other attorneys that said, all with these other lawyers advising, all what they want to do is charge you more money, which is honestly is stupid advice. Because the world of transfer underlying basis is a world of confusion and trying to chase your tail. In EB3 versus EB2, which is moving first, and how to jump back and forth in a system that's completely inaccurate. And you can't follow through. Yes, absolutely. And money should not stop you from filing two applications and let each one fight for its own survival. And if one reaches the finish line first, you get the green card, and you don't have to worry about transfer underlying basis.
Yeah, the transfer underlying basis is tantalizing. It's, if I just send a letter, I'll have my old long processing I-485 case, and it'll be current, and they'll approve my case immediately. And they never do. And are they going to approve your new I-485 case immediately? Probably not, but sometimes they get those second ones really fast because they've done all the groundwork in the other case. And the answer is you can just sort of kick back and say, if you're the sort of patient person, fine, these things are going to erase whatever category they approve me in. I'm going to be done with it eventually.
It's your green card.
Yeah.
Spend another 5 or 10 grand on it.
Yeah.
And
relieve yourself from the anxiety of this.
Yeah, and forget about it and watch it. Watch it unfold before your eyes.
Yeah.
My EB1C priority date is June 2022, India. Could you please share your perspective on when it's realistically expected for the EB1 India final action date may advance to past June 2022 based on current Visa Bulletin movement trends and available quota projections?
Well, I am looking at the October Visa Bulletin right now,
Yep.
and it says the India EB1 dates for filing are 15th of April 2023. And if we go by what we believe they're doing with it right now, it would suggest that that date of June 2022, which they're not quite at. Wait a minute. The final action dates for employment-based preferences is in 15th of February. I couldn't see very well. So sometime this year is my short answer. Yeah. Fingers crossed for you.
So that's the best we can do, because honestly, no data is going to give you what the government will do.
Yeah.
Because the government relies on published data and a lot of unpublished policy and information that we don't have, and therefore absolutely not possible for us to project.
Yeah, even if this Visa Bulletin suggests it right now, who knows what happens in the middle of the year when they run different numbers, you know?
Yeah. We run out of time. As I said, drop your questions in immigrationquestions.us. You don't have to put your name or email address. We will do our best, and if you provide your email address and we're not able to include it here, we'll email your response as a courtesy, but you don't have to put your email, you don't have to put your name, and it will be completely anonymous, where you can ask your questions without being posted or attached to your social media handle, which will be probably a better way under the current circumstances. You guys have a fantastic rest